Okay, hopefully everybody had a chance to get something to eat, and thanks again to Professor Vogel for making ethics great again. Also, thank you for all our Nebraska alum who came up. I don't know how many of you tracked that story about the volleyball team using the football stadium and breaking all sorts of attendance records. I just thought it was really neat that they finally found a use for that stadium. All right, for our first panel of the afternoon, we have the fascinating topic of strategic competition and the rise of space lawfare. By the way, I had to buy General Dunlap 2 beers to get him to let us to use that name. To moderate this panel, we are delighted to have Major Jonathan Sawmiller. Major Sawmiller is the Chief of Operations Law for United States Space Command. Major Sawmiller is responsible for advising the combatant commander, his staff, and Joint Operations Center on compliance with international and domestic law and policy for global space operations, activities, and missions. Prior to his current assignment, Major Sawmiller served in a variety of judge advocate roles, clearly the most interesting of which was as a cyberspace operations legal advisor. Over to you, Buzzsaw.
Well, thank you for that kind introduction, Professor Biller. Good afternoon, ladies and gentlemen. I am Major Sawmiller, and I have the distinct honor of working at U.S. Space Command, Office of the Staff Judge Advocate, and I'm honored to serve as your moderator for this panel. We're discussing strategic competition and the rise of space lawfare. We have a distinguished group of panelists today whose impressive experience, credentials, and accomplishments are detailed in the printed biography books for the conference. I would ask each of them to please in turn introduce yourself and explain your organizational affiliation. And we'll rely on the conference bio books for all the long details of your careers. So Dr. Goldenziel, why don't you start off?
Hi.
Yeah.
Hi, I'm Dr. Jill Goldenziel, and I'm a professor at the National Defense University College of Information and Cyberspace and a non-resident fellow at NATO SHAPE Office of Legal Affairs.
Hi, my name is Dean Cheng. I'm a non-resident senior fellow with the Potomac Institute for Policy Studies, a non-resident fellow with the George Washington University Space Policy Institute, and a senior advisor with the U.S. Institute of Peace.
Hello, I'm Colonel Matt King. I'm the Chief of Space Law at the Headquarters Air Force Office of the Judge Advocate General.
And I'll round this out. I'm Jessica Talk with OSD Space Policy, so the Office of the Secretary of Defense for Space Policy.
Thank you. Our panel is titled Strategic Competition and the Rise of Space Lawfare. General Dunlap may have not copyrighted that phrase. It may have come from somewhere prior to that. Dr. Goldenziel, can you briefly explain to our audience what lawfare is in the context of international relations? Where did it come from, and what kind of actions does it refer to?
Sure. So China had lawfare before we did. Actually, lawfare is more ancient than that, but China coined the term legal warfare, I would say. I'm going to ask Dean to actually pronounce the Chinese version because he has written much more about this than I have.
法律战.
Yes,
Will be a test.
he can do that well better than I can. So that term roughly translates to lawfare. More accurately, legal warfare. And legal warfare is one of China's 3 warfares that date back in their military doctrine to at least 1963, possibly earlier. And they've more recently been crystallized in the political work guidelines of the PLA, People's Liberation Army, as of 2003. That's where they've been really most clearly spelled out. So these 3 lawfares are meant to be used in tandem with each other. First is public opinion warfare, otherwise known as media warfare, which involves shaping public opinion domestically and internationally, roughly similar to what we in this audience tend to think of as information warfare. Then psychological warfare, involving influencing foreign decision makers regarding China policy and regarding China's place in the world. And so this is roughly similar to what we think of as PSYOPs, but a little different because it's about influencing foreign decision makers involving China's policy with a focus on getting the adversary to factionalize. And then the third warfare, which we're talking about today, legal warfare, involves shaping the legal context for Chinese actions using both domestic and international law. And as I'm going to talk about a little bit more later, we don't have yet, we're starting to have anything equivalent to that in US military doctrine or US national strategy. And as China has been using it more and more, I see that as a bit of a problem.
Thank you, Dr. Goldenziel, for that explanation, the background of lawfare. I know you've got another slide here. I don't know if you got some more you'd like to talk through on this before we turn to Mr. Cheng.
It's hard to talk about the history of lawfare without giving a shout out to Charlie. It's already been shouted out about 3 times. Charlie, back when he was a colonel, and he later became a major general and is now a professor at Duke Law School, really brought the term into the US Legal Academy. And this was his initial definition. He evolved it a little bit in 2001, a method of warfare where law is used as a means of realizing a military objective. And he was thinking mainly at the time, we all know what was going on in 2001, violent non-state actors using things like human shields against the US and then coalition forces. And Ord Kittredge came along and wrote a great book in 2016 called Lawfare, Law as a Weapon of War, where he developed the concept a bit more and talked also about economic lawfare as well.
All right, thank you, Dr. Goldenziel. This panel is about strategic competition. And let's turn now to one of our strategic competitors, the People's Republic of China. Mr. Cheng, how does lawfare fit into the PRC's approach to international relations?
Well, so to begin with, to build off of Dr. Goldenziel's comments, think of political warfare, all 3 elements, as the hardest form of soft power. So within that context, what is the purpose of political warfare? And it is warfare, which means, since we're here at the Air Force Academy, the principles of war apply. Musmas, right? Mass, offense, surprise, unity of effort, simplicity, efficiency. So that is how the Chinese think about legal warfare. So within that context, the Chinese conduct of legal warfare is very different from what General Dunlap and Ord Kittredge and others have portrayed, because they are coming at it, to begin with, from a very different context. China is a rule by law society, not a rule of law society. The law exists to protect the state. The law does not exist to work out problems among individuals, and it certainly is not there to defend the individual from the power of the state. So legal warfare then, in that context, is not an effort to determine the legality of an action. It is the use of the law, and here it is the most expansive definition: law, international law, regulation, law enforcement activities and operations in pursuit of strategic goals consistent with the principles of war: mass, objective, unity of effort. And therefore, for PLA practitioners of legal warfare, the point here is to use the law to achieve strategic objectives and to underscore the message. What China does is legal. What you, the adversary, does is illegal. And if China has to do something illegal, you made them do it. The other thing to keep in mind is, because of the issue of offense, is that a Chinese military lawyer, and there are quite a few of them, they all reside within the political work department, their purpose is, again, to support military operations and broader strategic operations to help China achieve its strategic goals.
Thank you, Mr. Cheng. Are there some good examples you could briefly discuss of how the PRC has employed lawfare in non-space domains?
I make no promises about being brief. But the best example here would be the South China Sea. And let me give 2 broad examples of it. 1, China is a signatory to the UN Convention on the Law of the Sea, and yet it refused to abide by UN UNCLOS rules about dispute arbitration when the Philippines, another signatory, took it to court over the issue of the exclusive economic zones and China's 9-dash line. There are probably actual maritime lawyers here, and I should have said this up front. I am not a lawyer. That makes me very nervous in a room filled with lawyers, like a long-tailed cat in a room filled with rocking chairs. So the point here is that what the Chinese version of exclusive economic zones versus the Western version is that the Western version is that the exclusive economic zone, which goes 200 nautical miles from your shore or baseline, is international waters where the owning state has the right of first refusal to all the resources, fish, oil, minerals. The Chinese version is that the EEZ should be treated like national waters, territorial waters, where other nations' peaceful shipping, meaning merchant shipping and airliners, may pass through, but warships and others cannot. A very fundamentally divergent view that the Chinese have now applied to the 9-dash line. The other example that applies here is, what does China use to signal its control of the South China Sea? It is not gray hulls. The Chinese Navy is present, but almost always over the horizon. What is the first line is the Chinese Coast Guard, white hulls, law enforcement vessels. There is a political message here. The message is that it is no more necessary for China to use the Navy to enforce the law in its own territorial waters. Mind you, the 9-dash line extends hundreds of miles from China's baseline. But China does, because it's Chinese waters, China doesn't have to send the Navy, it sends its Coast Guard the same way that Illinois would send the Illinois State Police, not the Illinois National Guard, much less the 82nd Airborne, into Chicago to enforce the law. This is political warfare, it is messaging, it is also legal warfare, the use of a law enforcement entity to send out a strategic message.
Turning now to another strategic competitor, the Russian Federation. Dr. Goldenziel, how does lawfare fit into Russia's approach to international relations?
Russia's main goal is to attack the legitimacy of US law, US democracy, and international law as well. Russia sees international law as a Western tool of domination. They've accused the US of colonialism in its efforts to shape international law and international norms, particularly in space. And Russia has also used legal tools in conflict, in its conflict with Ukraine in particular. First of all, Russia lays a foundation for basically everything it does through creation of law in the Duma. It was actually possible to predict when Russia was going to invade Ukraine, precisely because of the legal framework that it created up to the moment that it invaded. Russia has also used, as many in this room I'm sure are familiar with, little green men, particularly in its invasion of Crimea, in order to slow the Ukrainian response and reduce escalatory risk. So for any who aren't familiar, Russia initially sent in what became known as, rather sarcastically actually, as little green men in Crimea, people dressed in green without any sort of uniforms or insignia. And Putin was able to then claim that it was local forces that were engaging in a takeover of Crimea, and at least have plausible deniability there. And then, of course, it came out later that they were in fact Russian special forces. And just creating confusion managed to slow the Ukrainian response and also put them in a bind in terms of the way that they could legally respond. Russia's also engaged in passportization of neighboring states, passing out Russian passports to ethnic Russians, Russian language speakers, and then passed a law saying, well, it's Russia's responsibility to be the protector of these peoples, and then use that as part of its justification for Ukraine.
Thank you, Dr. Goldenziel. We're at a U.S. Space Command legal conference, and so maybe we should probably talk about outer space a bit now. I'd like to give each of the panelists a chance to address some specific responses to the following journal question. How do the PRC and Russia employ lawfare to advance their interest in the space domain? Let's start with Colonel King. Sir, can you provide some background on the Russian and PRC role in the prevention of an arms race in outer space saga?
Yeah, thanks. Yeah, I think this is a good example of efforts by both PRC and Russia. And I think as far as the lawfare definitions we have, it really tackles how it's legal, but it's also political. It's about public opinion as well. So for those of you who have heard of it before, PAROS it's a movement that goes back to the early 1980s in the UN Conference on Disarmament, where it was an ad hoc committee that got voted on every year. And frankly, the US had abstained from all those votes, was not supportive of it then. But fast forward to the early 2000s, I think that's where we saw a bit of a change, and both PRC and Russia started to take more interest in it and started leaning forward in pushing for and trying to show active support for this PAROS, the Prevention of an Arms Race in Outer Space. And frankly, on its face, what the committee was going to be talking about, or when there are resolutions proposed on PAROS, they, again, on their face, they're not necessarily all that contentious. Nobody wants an arms race in outer space. That will lead to conflict. So, but it is something that the U.S. had a well-reasoned skepticism about how we, as the U.S., would be bound by such a resolution or by discussions in the CD. So we had good faith resistance to it, and there were attempts to basically triangulate against us for an information purposes using this legal mechanism to basically make the U.S. look bad and like we were counter to the peaceful uses of outer space. And it went up a notch in 2008 when the PRC and Russia sponsored, through this mechanism, something the full name of the treaty provision or the treaty proposal escapes me, but we call it the PPWT, the Prevention of Placement of Weapons in Outer Space Treaty. It has a very long name, but we all know it as the PPWT. But again, based upon, I believe, healthy skepticism by the U.S. about whether these two proponents of this treaty had any interest in abiding by the rules, by the lack of definitions within the initial PPWT about how it was only addressing outer space, not the direct descent ASAT capabilities that China had just demonstrated the year before, and we already understood Russia to have strong capability in. The U.S. came out against it. PRC and Russia renewed the PPWT in 2014 with some slightly modified language, but it was still just not enough to create any meaningful movement towards something the U.S. could support. Again, based upon this healthy geopolitical skepticism about whether they would even abide by their obligations were this to come to fruition as a treaty. But also just the lack of verification measures, which we believe are, which at least the U.S. has cited specifically in various state issuances throughout the 2010s as basically a conscious effort to avoid verification such that any PPWT wouldn't really have meaning. So essentially, if the U.S. signs on to an agreement, we will follow that agreement, and creating a space where there's an impossible agreement for us to sign on to by parties that we do not think will actually abide by it, it creates challenges for us. And I think that fits as an example of the lawfare that we're discussing.
Thank you, Colonel King. Ms. Tock, we're fortunate to have you here so soon after participating in an intersessional and formal consultative meeting of the United Nations Group of Governmental Experts on further practical measures for the prevention of an arms race in outer space. That is a mouthful. I had to write it down. How do Russia and the PRC use international forums and bodies such as the United Nations and International Telecommunications Union to advance their own interest in the space domain?
Sure. I think actually Matt just gave us a really good overview of what we've been seeing, or the U.S. has been seeing for a very long time in these fora. So I've had the luck to some extent of being the military advisor to various UN space-related forums. So not only do I touch the arms control side, which is what the PPWT rose from, but also the the UN COPOS, right, which was referenced earlier, the peaceful uses of outer space aspect. So in the United Nations, it's split into, space is split into two separate fora. These fora are constantly trying not to step on each other. They try to make sure that arms control stays separate than, civil peaceful uses, technical kinds of issues. One of those things that we've dealt with most recently, so I had the luck again to sit on as the military advisor to many iterations of the Paris GGE, which is the Prevention of an Arms Race for Outer Space group of governmental experts. The Russians have run this twice. They ran it once in 2018 to 2019, whereupon the US stood up on the end day and basically said we could not accept the report as it was written. And the report was not adopted by consensus. Move forward to about a year ago, the the Russians sponsored yet again another Paris GGE, so Paris GGE 2.0. We we nominated an expert, one of our State Department colleagues, to head up basically a small delegation consisting of him, me as a military advisor, and one other state person. In this, and we are in the middle of it, we just came back from the intersessional where basically the chair gave a readout. I think just to kind of summarize everything, you've heard this morning, I think, Almudena from UNIDIR reference the open-ended working group on reducing space threats through norms, rules, and principles of responsible behavior. So everything at the UN is long-winded, right? Everything, because it's all consensus. And the more you come to consensus, there's that joke about, a committee set out to design a horse and they created a camel. So just like that, we have very, very long names for most of these committees. What you'll see is, and I'm going to admit it, the Russians and the Chinese did a really great job. For years, they controlled the narrative. They said, we are against the placement of the weapons in outer space. And if you didn't know what that meant, if you were a country that basically said, yeah, I don't like weapons in outer space. I want to keep space for peaceful uses. It was something that was just really morally easy to sign up to, right? And what you saw, on the other hand, was the United States constantly standing up and saying, no, we have concerns. And that became a really difficult and tenuous position, right? And Matt kind of covered some of the reasons, right? For example, one of our key concerns is, what is a weapon, right? What is the placement of a weapon in outer space? What constitutes a weapon? So for example, I'd like to give you one of the Russians' favorite quote unquote weapons, which was the Canadarm, which was mounted on the space shuttle, went out, grabbed the Hubble telescope, and they go, that's a weapon. And Canada has been consistently for years going, did we do anything that was weapony with the arm? We don't think so. It was all scientific. And then we told you this for years, and the Russians are like, nah, that's a weapon. So you're looking at things that could have beneficial use, right? Earlier today, you heard a lot of people talk about, we don't want to stop new and novel uses. Honorable Carolyn Krauss said, we want to make sure that we're able to do new and novel activities. And so as the United States goes forward, we started to take a different tact, and this turn really occurred around 2019 when we came out of that first iteration of the Paris GGE, and we said, wow, this focus on legally binding initiatives, which is what the Russians and Chinese want to hold us to, is just untenable. So where do we go next? And that's where you've heard this kind of shift towards the word norms, right? And it's been in our space policy, it's in the space priorities framework. It is said over and over in the US government, we want norms of responsible behavior. What are norms of responsible behavior? Sometimes we look at it and we go, okay, is it customary international law? Is it soft law? Is it what constitutes norms? And in this case, we go, hey, you know what? We are not against legally binding rules eventually, right? But we want to make sure that they can be proved out first. And I think a lot of this was talked about in an earlier session as well. So we want those transparency and confidence building measures to basically be able to build the trust between states demonstrated over time of what constitutes responsible behavior, and the fact that other states will sort of, observe those responsible behaviors. And then maybe over time you can build the trust to get to the point where you could have a legally binding initiative. And so those are the two separate camps that are essentially emerging now.
Thank you, Ms. Tuck. Dr. Goldenziel, in December of 2021, the PRC submitted a diplomatic note to the UN Secretary General under Article 5 of the Outer Space Treaty, complaining that two of SpaceX's, which is a US corporation, their Starlink satellites had a close encounter, quote, with the PRC's manned space station in low Earth orbit. What was the U.S. response to this complaint? And is the Chinese complaint part of a larger pattern of their response to the success of Starlink?
So this was a bit of a surprise to the United States. It seemed to come out of nowhere. And the US responded and said that in a note for ball. They said, first of all, had we known about this, we would have given China a near collision report like we always do, as has been routine since 2014. And also, China did not engage in the notification procedures. There were actually two incidents. So the report to the UN Outer Space Agency was the first that the US had actually heard of these incidents. So while China asked the office to remind the US of its, without saying the US, of their obligations under the Outer Space Treaty, the US shot back and reminded China of their obligations to engage in the particular, in the specific notification procedures that would have allowed the US to respond and react to this. And this is very consistent with China's strategy. First of all, China likes to make the argument that the US is not following its own laws. They like to say that the US's laws are a sham. They're making a mockery of themselves by not following their own laws. So it's very consistent with that. And secondly, China sees Starlink in particular as a national security threat. They're watching what's going on in Ukraine with Ukrainian forces using Starlink, relying on it. And they're wondering if the same thing can happen in Taiwan. Taiwan is actually building their own version of Starlink as well. And they're concerned about other initiatives that SpaceX has been involved in as well. So they are looking at ways to go after them using Lawfare as well.
Mr. Cheng, the PRC has announced that it plans on landing a human mission on the moon by 2030, a project they term the International Lunar Research Station. Its partners include Russia, Belarus, Venezuela, and South Africa. What significance does this project have for the development of international norms, standards, and perhaps even law?
So one of the interesting things to think about here is that when the Chinese say they are going to do something, and by this, I don't mean some random Chinese person. I mean, when the Chinese government, the CCP, says we are going to do something, they actually do it. And when they say we are going to do something by a particular date, they actually do it. So let me give a quick space example. Shenzhou-1, China's manned space project's first spacecraft, not the one that sent a Chinese astronaut up. The term that was associated with that program was Promise 8, Guarantee 9. What that meant was that hopefully by 1998, but definitely by 1999, Shenzhou-1 will have been launched. By the way, if you fail in the PRC, the result is not, oh, well, I guess we'll just have to give you a continuing resolution or something. There are actual consequences to program managers and other people. So 1998 went by, Shenzhou-1 did not go up. In 1999, the Chinese basically took the electrical testbed vehicle for the Shenzhou-1. They had about 8 test vehicles, each for a different subsystem, yanked the subsystems from several of the other ones, stuffed them all into the electrical vehicle 1, and in November of 1999, very important date, fired off Shenzhou-1, which went successfully into orbit, did a bunch of their subsystem tests, and was successfully retrieved. They had fulfilled the 1999 objective. What does that have to do with your question? So China has said that it is going to put a human mission on the moon by 2030. This has now come out from the highest levels of the Chinese government. We, through Artemis, have 36 members. We have more flags on our side of the conference table. Very important. But with each passing month and year, we were going to go back to the moon in 2024. Well, I guess we could still have a few more months to try. Or 2025, maybe 2026. I will say 2 things. One, the Chinese absolutely, by 2030, will have an astronaut landing on the moon and planting the 5-star flag at some location on the moon. But the broader issue is, in the longer term, the Chinese have said, we are going to set up a research station, not a one-off, not a Mao Zedong base, landing site. That means regular missions. So the question you should be asking yourself is, if the Chinese are doing 4 missions to the moon every year to go to the ILRS, and Artemis lands maybe 1 mission a year, what do you think will be the language of space traffic management in cislunar space? In the first panel, there was a whole discussion of governance and how practice influences the law. We can pass however many resolutions, we can have 45 flags on our side of the table. But if the Chinese actually land on the moon and keep going regularly, that has legal as well as policy implications.
Thank you, Mr. Cheng. And thank you all panelists for that enlightening look at the activities of our strategic competitors. I'd like to turn now and discuss what the United States and our allies have been doing in response. And Ms. Tak, I'll go back to you first, and you've already delved into this somewhat. Can you describe how our participation in the UN Committee on the Peaceful Uses of Outer Space and other international fora advances the interests of the US and our allies?
Sure. I think one of the things, as I was kind of just to draw on my points before, one of the things the US is trying to do is to show that norms of behavior, non-legally binding, voluntary just behaviors and state practices can eventually turn into LBIs. I think the reason we said, look, there's a proven path. And we are recognizing that people want legally binding initiatives. Eventually, we will be at the point where we can consider those legally binding initiatives. But right now, we're still at that point prior to, say, for example, the 1963 Outer Space Treaty. That did not just arise out of nowhere. That came from a series of resolutions, that came from establishment of principles, that came from a lot of work that came ahead of it before you actually got to the treaty. And so one of the things, and it was mentioned earlier, is the direct descent anti-satellite commitment. Okay, I wrote it, so I should know that better. It is the commitment not to conduct direct descent anti-satellite missile testing. And I might be stealing a little bit of your thunder, Matt. I'm sorry, but so I will kind of leave some of it to Matt. But the aspect of that was to say, hey, look, we've come into this open-ended working group on reducing reducing space threats through norms, rules, and responsible behaviors. So you know what? Do you know what is a responsible behavior? How about stopping the tests that we're seeing, like the Fengyun 1C, like the Russian test in November 2021, the ones that you saw earlier where people said, hey, look at all the space debris. I think specifically Leo Labs had pointed out the Fengyun 1C, and we go, look, the United States isn't going to do that anymore. We have no need to. We're not interested in it. Why don't we? This is horrific for the international community and space environment. So why don't we just make the commitment not to do that anymore? We will not test anymore. And so we took that forward into the OEWG, and it was kind of overwhelmingly, so there was a resolution thereafter that somebody noted earlier as well, and that resolution was 155-9. You can probably guess who the 9 were. It is not difficult to figure that out, but 155 nations said we support this call to action. And so from that, we said, hey, look, how does one build customary international law through long-standing state practice done out of a sense of legal obligation? So we have gotten to 37 nations, and we continue that work to say, please commit, please make this commitment. And by doing so, we will therefore be able to show that this can become a norm of behavior, and then therefore can eventually possibly be considered as an LBI.
So Colonel King, you're the uniform member of the panel up here, and we were going to ask you about specific weapons technology like that November 2021 test of a Nudal direct descent ASAT missile. It did destroy the Cosmos 1408 satellite, Russia's own satellite, created a significant debris field, over 1,500 new pieces of a traceable debris fragment, and it posed a collision threat to space objects in LEO, including the International Space Station. Ms. Tak has already touched on some of the responses in the United Nations. Is there anything else you'd like to say about our responses in the public affairs arena or other type of unilateral responses?
Yeah, absolutely. And I was excited. I was going to get to announce a kinetic ASAT ban, but Jessica beat me to it. And the vice president did as well in April 2022. But no, so you mentioned the test, November 21, and pretty immediately, you know, the first wave is the public statements on this. And so USSPACECOM and General Dickinson in particular had comments about it, calling it, essentially it was a name and shame campaign. He said it was a deliberate disregard for the safety and security of the space environment. Similarly, Secretary Blinken called it, he said that the Russians recklessly conducted this test and described it as irresponsible. And the NASA administrator, Nelson, had similar comments to Secretary Blinken. So the first stage is that calling out behavior that we think is, I'll say irresponsible, because that's our magic word. And as lawyers, I think we can read into that, because the one thing that wasn't said is that it was illegal. We did not say that, but we called it irresponsible. And then that led to greater movement within the government, though, and as mentioned a moment ago, unilaterally in April of 22. So not that many months later, you know, five months later, which is pretty fast by government time. Vice President Harris announced the unilateral, basically a moratorium or a stop to the destructive ASAT testing that we do. And then, as Jessica described, we pushed it forward and pursued that in the UN and got a General Assembly resolution on that. Interestingly, I should note, though, back to the prior discussion, that passed overwhelmingly. Not that people will commit to a test ban, but that they should. And then some have come on and unilateral or have on their own committed to an ASAT test ban. But the PAROS came up again, and it was basically along the same voting lines as it had always been. I believe it was in the same vote. So some things advance, some things kind of stay the same in this realm. But just one thing I want to note is we can talk about, and I think we'll talk later about how do we do this, but you know, none of these things just happen. I'm confident that General Dickinson didn't just say, you know what, I want to make this statement right now. I don't care what anybody else has to say. I'm going to say it. I suspect Secretary Blinken ran it by a few people as well. So in all of these efforts, and just like Jessica described about even our efforts at the UN, it's a whole of government effort, which makes it hard because, you know, we're the United States. We have a lot of different arms of our government. We have a lot of different agencies, even within the executive. And that makes it tough to take clear and unilateral and quick action, even in the information space.
Thank you, Colonel King. Mr. Cheng, we've already discussed the PRC's International Lunar Research Station project, and there's been discussion already today of the Artemis Accords. As of February 2024, I'm tracking 36 signatory states to the Artemis Accords, including major spacefaring nations such as the United Kingdom, France, India, and Japan. What is the significance of the Artemis Accords to further development of law in the space domain, and how does that compare to what the PRC is doing with their research station project?
Well, I'm glad that we have lots of partners on our side of the table, because it just means that we have more flags on our side of the table, which means that we get to say that we are winning. It's very important to say we are winning. On the other hand, when we look at, you know, sort of this, for example, the ban on ASAT testing, that debris generating ASAT testing, and we compare it with what the Russians and Chinese have done, which is openly test debris generating kinetic kill ASATs successfully. What I do wonder about is what our own military planners and our allied planners think in the event of a conflict, which is to say that our adversaries have a demonstrated working capability. And in the case of the Chinese, at least according to the last couple of DoD reports on China, they have deployed them not as one-offs, but at unit level. So there are units of ASAT forces deployed with the People's Liberation Army. By comparison, we have the Artemis Accords, 36 countries that say we are all going to use space peacefully. Which deters more? Which coerces more? And then when we think about the context, again, of setting norms in space, if the Chinese set up a working facility on the moon, which almost certainly will, by the way, not be a military site, what does that say about a system that says, if we're going to do something by a certain date, we'll do it. If we want to coerce you, we have a demonstrated capability, while you have more flags on your side of the table.
Well, with that sobering thought, let's turn to what a broader U.S. strategy for a lawfare response might look like. Dr. Goldenziel, you've published a law review article addressing this. Can you give us a brief summary of your thoughts on tackling this problem?
Sure. I usually talk about this all day, most days, so I'm relying on you to keep me honest on time. So in 2021, I decided to write a law review article on lawfare, and I wanted to take the definitions that I showed you on prior slides and really bring them up to date to reflect the way that states are using lawfare and also the way that lawfare could be used to achieve US strategic objectives. So I came up with this definition: the purposeful use of law to achieve a particular strategic, operational, or tactical objective against a particular adversary, or to bolster the legitimacy of one's own or weaken the legitimacy of an adversary's strategic, operational, or tactical objectives. And this, to me, encompassed some of the ways the US has used lawfare, because we've been using it, even if we haven't been doctrinalizing on it, making it doctrine, and also the way that China sees us using it, since they think we're the world's most sophisticated practitioner of lawfare, and I think they're the most sophisticated practitioner of lawfare, so it affects the way, it reflects the way they've been using it as well. And what's happened since is that Indo-PACOM developed a counter lawfare program based on this article, and they took this definition, and this is how they're defining lawfare as well. So UCOM is going to they have a nascent counter lawfare program, and I know there's interest from Southcom as well. So while we don't have a doctrinal definition, there is a working definition, I would say, within parts of DoD. I don't neither want to undersell or oversell what I've done here. So this is what we're looking at. So I defined 5 types of lawfare. Indo-PACOM added a 6th one. And as far as developing an overall lawfare strategy or incorporating it into operations, this is a framework for 6 ways that it can be used. And the first thing I say, because there are a lot of words on this slide, when I talk about this slide, is don't think about this too hard, right? It's a framework. It's like SMART goals. You know, if you think too much about whether one is measurable or timely and they overlap, like, that's fine as long as it works, right? You can have lawfare that is more than one of these 6 types of lawfare, but this is a framework for breaking down what can otherwise be an amorphous concept and think about ways that the US could strategically use lawfare in order to combat or counter a particular type of lawfare, or in order to use it for our own purposes. So battlefield exploitation lawfare, I like to think this is something our adversaries do, not so much us, but exploiting an adversary's law abidingness. So the classic example here would be human shields. Instrumental lawfare, using law to achieve a traditional military objective. An example I like to use here is the Philippines lawsuit against China, the South China Sea arbitration, in order to set new norms in the South China Sea that have really become the basis for discussion and action since then. Information lawfare, using law to control the narrative of conflict. And this is something I think we're doing in conjunction with the next one, institutional lawfare, creating new laws and institutions to support military and strategic efforts when we create something like the Artemis Accords. So we've created this new instrument, might be non-binding, and we're using it in the information domain to talk about what's right and wrong, to really start to create norms and eventually customary international law in this space. But until that happens, because it can take a while, we can use it to say China's being the bad guy, China's violating these norms, Russia is going against what the international community thinks, et cetera. Proxy lawfare, legal actions by or against adversary proxies. So we're seeing that when we are dealing with Chinese state-owned enterprises, one of the things that or Chinese corporations that are of course state-linked, one of the things we haven't talked about here is Chinese-backed lawsuits to harass US-based corporations or gain intellectual property through the discovery process in lawsuits, something that came up in a recent House China Committee report. I see that certainly as proxy lawfare. We can talk, we don't have to talk about TikTok because we all know that we certainly view that and also Huawei as a proxy for the Chinese state. And then partnered lawfare, supporting lawfare by partners and allies. INDOPACOM works very closely with other states, particularly Australia, Philippines, and Japan, to develop shared understandings of what law is and should look like in the region. They also work with academics, and I am one of them.
All right, well, thank you, Dr. Goldenziel. We've got about 4 minutes left before we open the floor up for questions. So Colonel King, I want to turn to you because you've also published an article addressing this question about strategies for lawfare response. But specifically, what role do you see for the Department of Defense and Department of Defense attorneys in a broader lawfare response?
Yeah, thanks. I think we have to remember that when we're talking about the, the instruments of power, this is, when we operationalize it like this, it fits in DIME, it fits into the informational instrument of power, and that's not necessarily something that DoD owns. And a lot of the fora that we would be doing these activities in, whether you want to call them lawfare or if you just want to call it international engagement, DoD is not going to own that. We can certainly support it, and we should support it, but I don't know that we're necessarily going to be the primary actors for a lot of those. But that doesn't mean there aren't ways that the DoD can participate. And this is not a space example, but I think the Freedom of Navigation program is a huge example, and it goes directly to what Mr. Cheng was talking about in the South China Sea, but it's worldwide. But that is the DoD actively demonstrating support for us customary international law, but for everybody else, the UNCLOS, the borders and the boundaries that exist in primarily sea domain, but also to some degree in air. So we can participate and we can be the front of those types of things. For what DoD can do otherwise, Dr. Goldenziel mentioned some efforts in INDOPACOM especially, but also EUCOM, and I know we're going to hear more from them in the future. But I'm always a little uneasy calling that lawfare. I think I'm very comfortable with counter lawfare. I think we should be doing a lot to counter lawfare of others. But for the DoD to be actively engaging in what we're calling lawfare, particularly without a doctrinal definition, and I don't have a problem with the definition from Dr. Goldenziel, but if you see it defined in a lot of other places, it if not explicitly includes, it implicitly suggests a nefarious angle on it. And frankly, for DoD to operate in this field, it needs to be part of a broader theater plan. It becomes essentially information operations or information support to operations. And whenever you cram the law, which is objective, it is, we as the United States are fighting for what the rules are, not what that they, well, I mean, we should certainly shape what they should be, but when we're talking about what they are, what is binding, what is not, I think we have to be careful about putting it in terms of an info op, because that just has a lot of dangerous connotations to it. And that's okay for China, and that's okay for Russia, but I think part of what makes the United States strong, and I think this was highlighted very nicely in Honorable Crasta's comments, is that we thrive under the rules-based international order. So all we have to do is support kind of the ether that is around us as attorneys, as international lawyers. So we're not trying to create something, we're trying to bolster the thing that is there. So I think all of us in our practice at all different levels of the DoD can basically ensure that you are honestly reading the law, applying the law, and helping your commanders understand that maybe the long-term gains of adherence to the rule of law and following the rules-based international order, that is in the United States' best interest, even if it feels in a tactical or maybe operational standpoint that, well, if we could just get around this prohibition, that would really help me. Helping our practitioners understand that in the long run, it is better to bolster the law. I think that's how we can really all participate.
Very briefly, we've got to get to questions here, but if each of our panelists want to just take 1 minute to finish your thoughts there, and then we'll roll into questions.
Sure. I agree with all of what Colonel King said, and we'll just foot stomp two things. First of all, lawfare needs to be a whole of government approach in order to succeed, whatever it is that we end up calling it. I think it ended up in DoD because it's partially because it's where I sit, and also because anything with fair in the title is going to be DoD's responsibility, and it originated with Charlie, of course, who was here. So, but it has to be a whole of government approach, if for no other reason due to authorities. I mean, DoD can't file lawsuits representing the United States. So if we're going to realize what lawfare can be to its full potential, doing all of those 6 things that I mentioned on my slide or others, it needs to be a whole of government approach in order to work. And it's not going to be effective if it's only shoehorned into the information domain.
Thanks, Ms. Tock.
Period. All right. As noted, we uphold the international rules-based order. I will echo what Colonel King said and refer you back to what the GC said this morning. Again, we're not engaging in lawfare. We are bolstering the international order. And so everything that you will see the DoD support on in the UN and other multilateral fora, for example, is we went to the UN COPUOS, and it was a DoD person who actually led the team in terms of getting the 2019 LTS guidelines, the long-term sustainability guidelines. Those are, you look at them and they are about safety, they are about sustainability, they are about preservation of the environment and communication, right? Just putting together points of contact, et cetera. And those are the things that DoD are for. Responsible behaviors are things that the DoD are for. And I will, again, unequivocally say that we will not engage in lawfare. Thank you.
Quick points. One, I think it is vital to recognize China believes in the rules-based international order. It's the Russians who love anarchy. The Chinese believe in a rules-based international order. Their question is, who should write the rules? The second part here is that in our system, again, I'm not a lawyer. Everything I know about the law I learned from basically watching the paper chase, is that it is the duty of a lawyer to zealously represent their client. And I guess the question here is, what does that mean for military and defense lawyers in the context of lawfare? Should you be taking it from the perspective of the prosecuting governmental attorney who is always constrained and has to share their data with the defense, et cetera? Or should you be taking it from the perspective of the mob lawyer? And that sounds kind of obnoxious, but you know, they deserve to be zealously defended too. That is part of our context for representation, legal representation, et cetera. And so when you represent the United States, when you are conducting legal arguments, should you be perhaps taking the view the international order as we've written it is under attack by somebody who wants to substitute something different, coming from a fundamentally different philosophy? And how far should we go within the rules and bounds to zealously defend the United States and the international order from a legal basis?
Thank you, panelists. Let's open up the floor for questions at this time. Do we have any coming in from online first?
Good afternoon, panelists. And this, I believe, is directed at any of you. I know we've all talked about lawfare and also flags. The question comes from Mr. Listener, who is saying, any thoughts on the lawfare significance of the PRC raising its national flag on the moon?
That is going to be literally a game changer. How often have we heard, we're Americans, we went to the moon, right? Or alternatively, we went to the moon. How come we haven't solved the common cold yet? It is an example of American exceptionalism, something that has ruled the roost since 1969. What happens when any other nation lands on the moon? Yes, we were there first, but now somebody else has gone there. So the first point is China will have demonstrated it is now the equal of the United States. The question really, though, goes to what happens when the Chinese raise the second, third, and fourth flag on the moon? And that is going to be an even bigger game changer because, by the way, they will have beaten the Russians and the Europeans and the Japanese to them.
Thank you. Do we have any questions from the audience here?
Good afternoon, Major Brian Green, Space Training and Readiness Command. I was wondering what your thoughts are on if a country were to try to participate in both the Artemis Accords and the International Lunar Research Station, how should we think about those efforts and how would we respond?
As the DoD person that got to coordinate on the Artemis Accords, I would say that we had a similar question that was raised. I think this will be discussed a little bit later in an actual Artemis Accords panel, but we do not stop people from working together. In the interest of transparency, in the interest of international cooperation, we should allow everybody to work with whom they wish.
All right, any additional questions from the audience? See a hand up here. Nick, it's not about Mustache March, is it?
No, it is not. Nick Mahanic, SPAC, Space Operations Command. So question for all of you. We heard a lot about the US reacting or acting in a reactive method. Colonel King talked about how the best way we can use lawfare or lawfare-like activities is in support of the rules-based order. And then finally, we heard confirmation that DoD will not engage in lawfare. Could there be a role for a more proactive lawfare response from the US and its allies, or are we, based on our position in the world and our ideology, inherently constrained? And what would that look like if we did?
I can start on that. So if I had my full slide deck here, I would have talked a lot about the term and why people don't like it and what our adversaries and allies call it. And I'll just say that my colleague at NATO, Andres Munoz Mosquera, likes to say, it's like this big monster and it's got giant horns and it's got giant teeth and it's coming after you and you don't know its name, but you know you've got to do something about it. So that's how I really like to think of it. The term lawfare has been around for more than 20 years in the legal academy, so it's what I chose to call it. But I think I'm losing the fight in terms of as an Aussie one star who's not here once told me, Jill, it just doesn't sound like something nice that we're calling that we would do to other people. And I said, all right, you got me. Like I don't really have a response to that. So, but whatever it is, we are calling it. First of all, the Navy also has a countering the misuse of law working group, and that is the reason it's called that instead of a lawfare working group is because one of the things that we were tasked with doing is to figure out what to call it. And I'm not sure what's going to come out of that working group yet, so I'm not going to do a spoiler alert, but one of the things that we've talked about a lot is that we need to be thinking more proactively. We need to be thinking more offensively and not defensively, which is something we do in the Department of Defense. And a lot of that does have to do with narratives and transparency and publicizing some of the bad things that our adversaries are doing, particularly China, also Russia, and really seeding the information space with the type of norms, even before we formally try to create norms of customary international law, that we would like to create, and seeding this narrative about what's right and what's wrong and what's good and what's bad for really the future. We're talking about the future of the Earth.
Mr. Cheng, go ahead, and then Colonel King.
Real quick. So norms that are not enforced aren't norms. They're nice little ideas that probably belong inside a fortune cookie. I think I get to say that. So consider the following. The Chinese Tiangong-1 space lab came crashing to Earth uncontrolled. After the Chinese said, no, we got this under control. We know exactly where it's going to come down. And then about 3 weeks before it came down, it was like, we have no idea where it's going to come down. The Chinese launched Long March 5B boosters, great big honking things with multi-ton engines. The entire thing goes into orbit, drops off its payload, and the entire thing, including multi-ton rocket motors, then come crashing back down to Earth. Mostly in the water. Earth is mostly water, but at least twice, once into the coast of the Ivory Coast and once off the coast of Malaysia. What has been the United States response? I don't care who does it. It could be the Department of the Interior for all that it matters. The response has been a thunderous silence. Do something. Legal warfare, okay, we don't want to do it because it sounds nasty. We need to come up with a nice word. How about unicorn policy? Okay, everyone likes unicorns. We should pursue unicorn policy when the Chinese violate norms that we say we want everyone to follow, like controlled deorbiting of large multi-ton objects. So somebody please pursue unicorn policies.
Colonel King, are you with the Department of Unicorns?
Yeah, absolutely. I think I've been accused of that before. And I'll note, I don't want the caution about DOD's role or the use of the term lawfare to get in the way of the fact that I do think we should be more engaged. I think we can be and should be, certainly inappropriate for DOD. But I think as a whole of government, I think we can be more engaged. And we've done some things, and I think we heard about some of them this morning from certainly with Artemis, but some of the different panelists. And I know, Professor Beard talked about WUMRA. That's not an info op, but it is an area where they sought out the views of governments and government practitioners, the people who actually do the law that is the law of armed conflict in space, and they sought the views of the practitioners. So again, it's hard for the U.S. because we're kind of stuck with the facts, and we're stuck with how the law is. We're not trying to manipulate the facts or make up the facts as some states do, or just manipulate what the law actually is as other states do. So it makes it hard, but that doesn't mean we shouldn't be engaged. So I just want to be clear. I think we should be engaged, to your question.
And Ms. Tuck.
Okay. Despite my earlier discussion, so what it was, I think we are arguing over semantics, right? I mean, to some extent, like the U.S. will pursue its objectives. Those objectives may be underpinned by some of the things that were on the slide, right? And ultimately what Colonel King was saying, we will pursue an international-based order. That international-based order has been beneficial to the United States and has been beneficial to securing peace and security and stability for years. So therefore, we find a lot of utility out of it. We will pursue it. We will bolster it. We, just to make a quick iteration on what Dean was saying, I love unicorn policy. I am for sprinkles and unicorns and cupcakes, and we will pursue that. And how we will do so is by consistently putting out messaging, right? Every time that China brings in a Long March 5, there is messaging that goes out from various parts of the US government that say, this is an uncontrolled reentry. And you see China violently push back. They're like, no, we're not the only ones that do uncontrolled reentries. Other people do uncontrolled reentries. You are making things up. But you can also see a change in their behavior. They have actively tried. We believe that they have actively tried, and we'll have to check with our technical experts, but they have actually tried within, I think, the last 2 reentries to try and mitigate where it comes down. So there are things that occur, right? Like the messaging is not unheard. And so when we're trying to do these shifts, right, we've gone to the IADC, the Interagency Debris Committee. No, that's not it. But the IADC is made out of, I think, 17 or 18 national space agencies. They're the ones with the debris mitigation guidelines, right? The ones that the UN debris mitigation guidelines are based off of. Those, China's part of that. China agreed to those guidelines, and the IADC itself ran a reentry when China was bringing in the reentry, and they said, you know what? Why don't we as a group highlight a reentry that's coming in? And they chose China. I don't think the Chinese particularly enjoyed that. And so we do see that they are changing just the same way that like the US is responsive to criticism and feedback, right? As somebody said earlier, the note verbal that the Chinese sent to us that said, oh, America, you guys don't care about astronauts and you don't care about the Outer Space Treaty. We said, wait. We care about all those things. We care about the Outer Space Treaty. Why did you wait 6 months before you got a hold of us? Let's go back and check our data. And we checked our data and we said, we didn't see anything that meets, over a decade of conjunction thresholds. This didn't meet an emergency. So come talk to us. Do you want to open that line of communication? Because this is a problem about communication. So let's do the thing the United States is known for. Let's go do the transparency thing. Let's go open those lines of communication. Let's be the nation that says, we want to talk to you about this. And those are the same principles that underpin the Artemis Accords. Those are the same principles that underpin our US space policy and our national space priorities. And we will continue doing that.
Well, it was a great discussion. We've got time for another question or two. Do we have any more on?
Hi, my name is Travis Cottom from the Institute for Defense Analyses. The panel, you guys gave examples of Russia and Chinese lawfare activities within the UN, at COPUOS and CD. Have you seen any similar type of activities at the ITU or the WRC?
The ITU, the International Telecommunications Union, is a specialized agency of the United Nations. In the United Nations, you see, you see China and Russia sort of bringing in questions about Starlink, right? You see them start in the first committee, which is arms control, the fourth committee, which is, again, peaceful use. And then you see those sort of slide into the ITU as well. And they all come from different angles, right? So you can tell that they're concerned. Mostly in the ITU, it is from Iran, right? They have pretty much made a complaint, and so as anything, like the ITU is taking a look at that.
Mr. Cheng, and then we'll get Dr. Goldenziel.
So internet governance is managed only somewhat through the ITU and a lot through ICANN, the International Corporation for the Assignment of Names and Numbers. The Chinese and Russians have worked assiduously to undermine ICANN because it takes a multi-stakeholder approach that allows not only nation states to participate, but non-governmental organizations, religious groups, etc. And the Chinese argument has been only nation states should have governance authority over the internet. They have worked when there was a Chinese citizen in charge of the ITU. They basically worked with that person, despite that person's pledge to take a purely UN approach, to basically work assiduously towards Chinese goals. The other thing at other UN organizations has been, when the Chinese have been in charge of places like ICAO, has been, for example, to ban the presence of any Taiwanese representation or even Taiwanese journalists on the grounds of they're already represented, they're Chinese, which is, I think, an aspect of legal warfare.
Dr. Goldenziel? We've got 2 minutes left. Professor Davis, do we have any more questions coming in from online?
We do. While we're on the subject of Russia and China and the PWT, an anonymous attendee asks, what are the key mechanisms used by the COPUOS to advocate against the draft proposed by Russia and China with regard to the same?
Could you repeat the question?
What are the key mechanisms used by the COPUOS to advocate against the draft proposed by Russia and China with regards to the PPWT?
I think it's in the CD, but I think it gets debated. I'm not sure that there's any special mechanisms. Like a lot of things, there's a lot of discussion and not a whole ton of progress towards treaties, but this is one where I know the U.S. has taken a more active stance in expressing concerns both at the sessions, but also in, with more public releases as well. So I think it makes it unique in that regard, but otherwise, I'm not sure of anything additional.
Okay, so with regard to the PPWT specifically, that is brought up in the arms control context. That is underscored by the UN First Committee. The Paris GGE 2.0 that is currently occurring from 2024 to 2025 is looking at aspects of a legally binding instrument specifically, and one of the things, quote unquote, inter alia, that they should be looking at is the PPWT. So one of the things that, of course, everybody debates is one, and so pushing back is to say, one, what is PAROS? Two, is the PPWT is it actually helpful when we go forward and look at what is a weapon in space? What is the use of force in space? Isn't that already banned by the UN Charter? So what is the assistance that this actually brings, like, to peace and stability? So there are a couple US, I think, responses to it that have been published in the Conference of Disarmament.
All right, panelists, thank you very much for your insightful perspectives and your willingness to share your valuable time with us today. Ladies and gentlemen of the audience, please join me in a round of applause for our panelists.
Thank you, Major Sawmiller, and our panel. For those of you who didn't know, speaking of strategic competition, this is a coin that has won many international strategic competitions for coin design. So please